I'm Jim Doyle. I'm a partner with Doyles Construction Lawyers, and we specialise in construction law, both in setting up construction contracts, in looking after the management of construction contracts as they're executed, and in resolving disputes at the end of the job. I'd like to speak to you about the High Court of Australia's decision on the 6th of September 2012 in the matter of John Andrews and the ANZ banking group. This case involved a number of banking fees which were imposed if a cheque was dishonoured or an account was overdrawn. The issue that was raised by the applicant, John Andrews, was that these charges were penalties. That is, they were out of proportion to the damages the ANZ might suffer by reason of the account being overdrawn or a cheque being dishonoured. Accordingly, John Andrews asked that the ANZ's charges be declared a penalty by the court and found to be void. The court considered in some detail, in a single unanimous judgment, the development of the law of penalties and the history, going back to Roman law, of how the doctrine of penalties had been used firstly by the Court of Equity in setting aside unconscionable bargains, and later adopted as a rule in the common law to punish those who had sought to impose an extravagant penalty for a breach of contract. The court held that the equitable jurisdiction was not finished, but had merely led the common law development to the stage where the common law also imposed bans on penalties, but the Court of Equity still had a role to play. The importance of the role of equity is that equity, by definition and in its nature, develops according to the times and responds to changing circumstances according to the good conscience of the court. Accordingly, this decision is seen as expanding the range of penalties which the court will declare void. In respect of construction contracts, there are many onerous provisions, all of which should be examined carefully in light of this decision. The most obvious application of the decision is in respect of time bars. That is, a clause which says if a claim is not notified within a certain time, it shall be absolutely barred. The aspect here is that the penalty for not notifying within the time is extreme. A claim for $1 million could be excluded on the previous authorities if it was notified a week late, leading to an unjust result. The court considered that the basis for the exercise of the jurisdiction of striking down a penalty was not dependent on the fact that there had been a breach of contract, but it could apply, and again, a wider range of circumstances. Accordingly, it's likely to become a very popular ground of objecting to time bar clauses, particularly by contractors who have many claims which are not notified in accordance with the contract. It will also be of importance when submitting claims under the security of payment legislation, because recourse should be had expressly and in detail to the application of the Andrews case to every time bar that would otherwise penalise an applicant. While there is authority in the security of payment area that says that those time bars do not apply to restrain the jurisdiction in the ambit of an adjudication determination, the Andrews case is comforting support to that position. Accordingly, I'd recommend that you look at the Andrews decision and in all aspects of commercial life, seek to apply the reasonableness of equity in response to the unreasonableness of many contractual provisions. Thank you.